For example, in August of this year, online media house Business Tech reported that Trade and Industry Minister Ibrahim Patel had tabled the new Companies Amendment Bill before Parliament. The bill proposes significant changes for businesses in South African law, including a requirement for listed companies in the country to disclose the ratio of the highest paid to the lowest paid 5% of workers in their reporting. This requirement would, I imagine, help us to address some important issues of inequality that pervade our country, where some of our top executives will earn more than 500,000 Rand a day compared to the average of 800 Rand a day or the poverty line of 25 Rand a day. The result of these disparities is that shareholders of listed companies are starting to vote against high executive pay at annual general meetings, particularly in the finance sector, according to this report. So in recent years, companies across the globe have been forced to confront a host of new and complex issues, including environmental, social, and governance investing, sustainability concerns, corporate social responsibility, focused stakeholder and shareholder activism. Also increased calls for corporate accountability and transparency, and campaigns aimed at the formal recognition of multiple stakeholder interests by directors. These new developments are the direct result of changes in societal values and priorities regarding the relationships between people, the planet, and profit, I guess. The Occupy Wall Street, for example, has been a rallying cry for protesters since the financial sector collapse some years ago. Just a week or so ago, climate protesters were arrested outside the Federal Reserve Bank of New York building in the United States. Our speaker, Professor Yeats, was instrumental in founding UCT's Corporate Law and Governance Unit 2 years ago to create a forum that will bridge the divide between academia and practice in the area and to pursue innovative, excellent, and relevant research and engagement and education in the field of corporate governance. This evening, she will discuss the limited progress of company law reform so far and the challenges that these new developments present for companies in our country. With that, I now hand over the podium to Professor Hutting to introduce our inaugural lecturer. Thank you.
Members of the UCT Executive, distinguished guests, colleagues, and students, it is my singular honor to welcome you all on behalf of the Faculty of Law to this momentous occasion, the inaugural lecture of Professor Jackie Yeats, a member of the Department of Commercial Law. So this event marks not only a celebration of her academic excellence, but it is also a significant milestone for our department, as it welcomes again a full professor in the field of company law. Professor Yeats follows in the footsteps of extraordinary distinguished scholars in this department, the late Professor Michael Blackman and Professor Richard Jooste, her supervisor. So, as the Vice-Chancellor said, inaugural lectures are special occasions in the academic world because they allow esteemed professors to share their expertise and insights with us. Now, a professor may do this by reflecting on their research and their teaching and the contributions they aspire to make. Allow me, therefore, to sketch a bit of background about Jackie's remarkable career that has brought her to this joyful occasion tonight. I can assure you we will be listening to a very special scholar. So Jacqueline Yeats received her legal education primarily at Stellenbosch University, from which she holds the degrees BA, LLB, LLM, which were awarded between the years 1991 and 1997. In 2016, she received her PhD degree here at UCT for research focused on the development of appraisal rights in South African company law, about which we will hear more later. So after Stellenbosch, Jackie was admitted as an attorney of the High Court and practiced from 1998 to 2005 in the commercial departments of Werksmans Attorneys and ENS Africa. So those two firms practice at the cutting edge, and Jackie specialized in the company law aspects and regulatory requirements of corporate transactions. But yesterday, she told me that in those early years of her career, she also had a stint as a junior law lecturer at Stellenbosch, where a seed was sown. And that seed was to germinate a decade later when she joined UCT. And aren't we lucky for that? She initially participated here in the law faculty in the commercial law master's program, where she was a guest lecturer, and she provided practical experience of the law in practice to our students. And in 2005, this all resulted in her leaving the high end of the law practice and taking up a career in academia at UCT. But I believe there are more to Jackie's story of becoming an academic. I think this is both anchored in her family history and her passion for teaching, which brings me to the little table in the room. Moot court, and I thought I should bring some exhibits with me to. So Jackie's grandfather was the distinguished Professor J.P. or James Yeats, who graduated in 1936 from Stellenbosch with his LLB. And in 1940, he joined the law faculty in what the centenary book of that faculty calls the classical period. Now, the period was classical because of the trailblazing work done by scholars such as James Yeats, who, for example, together with the Professor J.C. de Wet, produced scholarship of the highest order, and in so doing, they almost single-handedly created Afrikaans as a legal language in this country through the writing of classical texts such as the celebrated Die Suid-Afrikaanse Kontraktenreg en Handelsreg, which is the green book on the table here. Afrikaans as a legal language was thereby appropriated for university-level teaching, causing students to so taught to transform the law in the courts when they became judges and leading practitioners. Now, this historical process is again relevant today as we grapple with questions of how to promote indigenous languages in the teaching of higher education programs in law. What I wish to say about all of this family history is that ideas about how legal scholarship combines with the teaching of law therefore run very deep in the veins of the Yeats family. And I understand her eldest son, who is here with us tonight, is also a law student at the moment. Which brings me to Jackie's passion for teaching. Professor Yeats is today, as we've heard, the convener of our commercial law master's program. This is by far our most popular postgraduate degree in the law faculty. This year alone, it attracted 80 students. Its success is the envy of every law school in the country. And Professor Yeats teaches cornerstone courses on this program, including advanced company law, governing company relations, and advanced corporate governance. In 2018, Professor Yeats received the UCT Distinguished Teachers Award, and in 2020, she was awarded a Teaching Advancement at Universities Fellowship. I know that she greatly values the freedom and support that UCT offers her to deepen her scholarship of teaching, and it's rightly so. Her research interest in the scholarship of teaching focuses on incorporating creativity into South African legal education by using design thinking methods and active learning. And I understand that shortly she will be pursuing a qualification at the University of Oxford in creativity. I think this will greatly benefit her teaching in future even more. And I think it also provides eloquent testimony of someone who is perhaps an eternal scholar. And I hope the dreamy spires of Oxford will kindle that further. What I find so remarkable, and I return to the table in the room, is the type of scholarship that she has managed to combine with this creative urge. So this is scholarship output that has a very wide impact on the lives of corporate citizens and of the practice of company law in South Africa. She researches and writes primarily in company law in the classical sense, with a particular focus on corporate law reform, governance, and appraisal rights. Example of the impact of her research are the reliance on several High Court decisions on her doctoral research. She's the managing editor and contributing author to major legal reference works like the big black work on the table here. These legal works, ladies and gentlemen, are the workhorses of the law. Unlike other disciplines, you find the law in them, and they are used in the daily workings of lawyers, whether it's in the law courts, in the consulting chambers, or for in-house legal practitioners, state law advisors, and of course, they are standard fare in the libraries of our courts. I'm not going to name all of them, but you see some of them on the table there. And this brings me then to the work that Professor Yeats performs in the area of policy work. We've heard that she's a founding member of the Corporate Law and Governance Unit here in the Faculty of Law, and of which she's also the director. Tonight, the title of Professor Yeats' lecture suggests that we may hear more about ideas for law reform in her field. I know because she's told me that she feels that she's in the right location in an exciting period of history and in a unique personal position to be working deeply in the arena of company law and governance, as well as in the parallel world of legal education. In conclusion, the dedication of Professor Yeats to the principles of academic excellence and of integrity, and to the advancement of the greater good in her field, I will believe serve us tonight will serve us to enlighten when we listen to her. Therefore, ladies and gentlemen, please join me in welcoming Professor Yeats to deliver her inaugural lecture.
Vice Chancellor, Deputy Vice Chancellor, Professor Hutton, Professor Lowe, friends, colleagues, students, guests, thank you very much for being here this evening. And thank you, Professor Hutton, for that thoughtful and generous introduction. My lecture tonight is entitled Values, Vice and Voices, How the Evolution of Modern Company Law Reflects Shifting Societal Values in a Changing World. 20 years ago, when I started teaching at UCT, the following concepts either did not exist or were not regarded as particularly relevant to company law: sustainability, corporate social responsibility, ethical corporate culture, stakeholder capitalism, environment, climate change, corporate purpose, and ESG. There was some awareness of corporate governance and the King reports as a niche area of expertise, but these were not considered to be part of mainstream commercial practice, nor of the formal company law curriculum at UCT. Today, they form an integral part of any modern company law conversation. And the university curriculum, and I teach 2 LLM courses which focus almost exclusively on these concepts. The company law landscape has changed significantly. In this lecture, I will examine how developments in society, law, and commerce have impacted directors' duties, and what this may mean for directors and South African company law. This is a very big topic, but the role of the company in modern society is one of the most, arguably the most vital and important current debate in this field. And so I very much wanted to address it. However, I cannot possibly do justice to all the aspects of law and governance. In order to cover a century's worth of company law development, I'll have to touch lightly on some very complex issues. If anyone in the audience feels compelled to delve more deeply into any of these, I always welcome new master's or PhD research proposals. In South African law, the duties of directors are regulated by the common law and Section 76 of the Companies Act 71 of 2008. There are a number of directors' duties and a rich body of case law dealing with these. But for present purposes, I'm going to focus on a specific aspect of just one duty: the duty of a director to act honestly in the best interests of the company. This phrase, best interests of the company, is deceptively simple, but understanding and interpreting what it means lies at the heart of what is expected from a director. However, what is considered to be in the best interest of the company is not defined in the South African Companies Act. Instead, the meaning of the phrase has been developed by a long line of court decisions going back more than 150 years. One of the first cases in which a court had to determine what was in the best interests or for the benefit of the company was the well-known 1883 case of Hutton versus West Cork Railway Company. In this case, directors had made payments to employees who assisted them with administration procedures in a railway company that was being wound up. However, because the company was ending its legal existence, the employees were de facto redundant at the time the payment was made. Two shareholders, the Hutton brothers, challenged the payments because this reduced the amount that would be left to be divided amongst the shareholders on the final dissolution of the company. The court found that, in the circumstances, no matter that the payments may have been justifiable on some other basis, and no matter how well-intentioned the directors may have been in making them, in terms of company law, this was not permissible, because the payment of these amounts held no benefit for the company. The court delivered the following well-known dictum: the law does not say there are to be no cakes and ale, but there are to be no cakes and ale except such as are required for the benefit of the company. Subsequent to this, courts in the UK as well as the USA interpreted the benefit or interest of the company to mean long-term interests of the body of shareholders as a whole. This seems to have been settled law in the UK and South Africa from as early as 1902. The message was clear. The proper role and purpose of directors was to focus on the interests of the company, meaning the members, which generally translated into maximizing profit for the shareholders of the company. Nothing more and nothing less would do. This is known as the shareholder-centric approach. However, this traditional legal position became the subject of fierce debates and disagreements in the early 20th century, when Professor Dodd questioned the logic of obliging directors to act primarily for the benefit of shareholders. Thus, a contrary school of thought emerged, aligned with the concept of corporate social responsibility, that directors should be obliged to benefit in the exercise of their powers, not only the shareholders, but also other groups affected by the activities of the company. These include the company's employees, customers, suppliers, creditors, local communities, and the environment. This is known as the stakeholder approach. The shareholder-stakeholder debate resumed in earnest in the late 80s and early 1990s, triggered by the sweeping corporate governance reforms which were taking place all over the world. At this stage, both the United Kingdom and South Africa had undertaken major company law reform projects aimed at modernizing their company laws. An attempt to define what was meant by the company when considering the best interests of the company in the context of the shareholder-stakeholder debate was a core feature of these reform processes. The UK drafters identified three possible approaches to the issue. These were: A, shareholder primacy. This traditional approach is premised on the idea that directors have an obligation to ensure wealth maximization for shareholders and that a company is solely owned by its shareholders. With this theory, the idea that a company also exists for socio-economic purposes is not sustainable. B, the enlightened shareholder value approach. This approach also requires directors to maximize profits for the benefit of shareholders, with a qualification that directors are permitted to take stakeholders' interests into account on the basis that these remain subordinate to profit maximization and the interests of shareholders. This theory aims to strike a balance between protecting the various competing interests of shareholders and stakeholders by recognizing that a company is an economic institution as much as it is a political and social institution. The third option, the stakeholder or pluralist approach. In terms of this approach, shareholders are viewed as merely another stakeholder for directors to have regard to, along with the various other stakeholders. In terms of this approach, directors may be required, if necessary, to forego shareholder profits in order to advance the interests of other stakeholders in the company. The UK elected to adopt the enlightened shareholder value approach in the UK Companies Act of 2006. That's the second one I mentioned, middle ground. In doing so, Section 172 of the UK Act replaced the English common law duty of directors to act in good faith and in the best interests of the company. Section provides that the director's primary duty is to promote the success of the company for the benefit of the shareholders. The section states that in discharging their duties, directors are required to, among other things, consider the interests of the company's employees, need to foster business relationships, the impact of the company's operations on the community as well as the environment, and the company's reputation for high standards of business conduct. These matters are, however, still secondary to their primary duty, which remains promoting the success of the company for the benefit of the shareholders. The UK Companies Act also obliges large and medium-sized companies, which is measured by reference to turnover, balance sheet total, and number of employees, to publish an annual strategic report. The report must set out information on various items, such as the impact of the business on the environment, disclosures around the company's employees, social, community, and human rights issues, and the company's policies in relation to each of these matters. Finally, UK legislation requires large companies to include a separate statement in their report, explaining how, in the financial year in question, the directors took stakeholder interests into account when fulfilling their duties under Section 172 of the Companies Act. Back on home territory, 2 years later, in 2008, South African Companies Act was promulgated. As a company lawyer or an academic, the one surefire way to reveal your age is to refer, as I sometimes still do, to the 2008 Act as the new Act. My students often look quite understandably a bit mystified by this reference. After much debate and negotiation, the South African Companies Act also adopted the enlightened shareholder value approach. Although the DTI described the approach in similar terms to Section 172 of the UK Act, in explanatory documents that were circulated leading up to the publication of the statute, ultimately none of this detail or direction was included in Section 76. Relevant provision states only that a director has a duty to act in the best interests of the company. There's no further explanation as to what kind of considerations the discharge of this duty might entail. The Companies Act contains some other features which imply an enlightened shareholder value approach. For example, Section 7, subsection D of the Act states that one of the purposes of the Act is to reaffirm the concept of the company as a means of achieving economic and social benefits. The Act also incorporated some specific amendments which protect stakeholders, notably employees, trade unions, and creditors in limited circumstances. However, these are scattered throughout the Act, and there seems to have been no cohesive legislative approach to the various stakeholder protections which were introduced in this way. A notable feature of the Act was the creation of a new body known as the Social and Ethics Committee, or SEC. Companies of a certain size or which have a significant social impact, determined by means of a public interest score, are required to establish an SEC. This committee has a wide-ranging role, but its main function is to monitor the company's activities, report to the board and the shareholders with regard to certain specified matters, almost all of which relate to stakeholder interests and issues. The type of matters the SEC is obliged to consider include social and economic development, good corporate citizenship, environment, health and public safety, consumer relationships, and employment issues. This statutory creation has been construed by some academic commentators as a legislative attempt to address stakeholder interests through a different structural and procedural mechanism than the direct board approach adopted in the UK. However, generally speaking, the SEC has not been the effective vehicle for engagement, change, and accountability that its proponents may have envisaged. Research conducted annually by the Ethics Institute reveals that in many cases, the reporting function of the SEC is treated as a compliance box-ticking exercise by companies. One of my master's students in her research compared the SEC reports of a number of listed entities, and it soon became evident that cut and paste templates and content were being used quite frequently for this purpose. This implies that many companies did not and still do not take the SEC seriously as a monitor and guardian of stakeholder interests and related corporate activity. Unfortunately, therefore, when its activities are not properly managed or conducted, the SEC can be a bit of a damp squib. Both the UK and South African Companies Act are bolstered by comprehensive corporate governance codes. Both codes emphasize the critical role of stakeholders in the governance process. King 4, the fourth King Code in corporate governance, points out that it adopts the stakeholder inclusive model, in which the governing body takes account of the legitimate and reasonable needs, interests, and expectations of all material stakeholders in the execution of its duties over time. JSE listed entities must comply with reporting required in terms of King 4 for various aspects of the stakeholder-oriented governance regime. However, although the King Code applies to all companies, it's not mandatory for others to comply with its provisions. Therefore, it's commonly described as an aspirational code. The UK Corporate Governance Code also contains specific reporting requirements with respect to employee stakeholder engagement, i.e., how has a company incorporated the employee stakeholder interests into their business practice? And the same applies to certain environmental issues. This is far more prescriptive than the South African position, and in addition, it is a mandatory requirement. The challenging global social, environmental, and economic climate we are experiencing means the stakeholder-shareholder debate has only increased in intensity in the last decade. It is also inextricably linked with ongoing debates about the purpose of the modern corporation. Should it be governed and run for shareholder or stakeholder interests? In 2019, a somewhat radical Business Roundtable declaration on the purpose of the corporation disrupted the traditional shareholder primacy view of the firm in the USA and caused ripples around the world. The Business Roundtable is a non-profit association comprised of more than 200 CEOs of America's leading companies, representing every sector of the US economy. It released a statement on the purpose of a corporation signed by 181 CEOs who committed to leading their companies for the benefit of all stakeholders, customers, employees, suppliers, communities, and shareholders. This outlined a modern statement of corporate responsibility and a move away from shareholder primacy, and it further accelerated the shareholder-stakeholder debate. On the international stage, there are currently two prominent legal academic experts who represent the main schools of thought on this issue. One is Professor Lucian Bebchuk of Harvard Law School, and the other Professor Colin Mayer of Said Business School at Oxford University. In essence, Professor Bebchuk argues that stakeholderism would not benefit stakeholders and in fact would be counterproductive, making corporate leaders less accountable, having a chilling effect on governmental reforms to protect stakeholders, and giving false hope that executives would protect stakeholder interests. In addition, he maintains that the pact announced by the US Business Roundtable to tackle stakeholder issues represents a public relations move rather than a commitment to bring about meaningful change. I fear that in this respect, at least, he may have a point. Various research papers that have come out of the US, particularly from Harvard Business School since 2019, indicate that there's been no real improvement of the public perception that large corporations are delivering on these promises, nor any substantial movement in the operations and policies of the signatories which demonstrate any real change. Professor Mayer backs a model promoting corporate purposes that produce profitable solutions to the problems of people and planet, and which ensure that corporations do not profit for producing problems for either people or planet. According to Mayer, purpose-focused businesses can solve problems profitably and sustainably while improving the lives of both stakeholders and shareholders. Mayer states that regulation alone cannot fix a corporate culture that has prioritized returns to shareholders and egregious executive remuneration. Instead, What is required is a change to corporate purpose, culture, and values, not intensified regulation. It is not possible to discuss company law in this context without referring to ESG, a relatively recent development which has had a significant influence on corporate and investor behavior. ESG is an acronym which represents the environmental, social, and governance credentials of a company. It is a framework used to assess the practices and performance of a company on various sustainability and ethical issues. It also provides a way to measure business risks and opportunities in these areas. More and more investors use ESG criteria to evaluate companies and help determine their investment decision-making process, a practice known as ESG investing, which has grown exponentially in the last 5 years. Investors engage in these efforts not only for altruistic reasons, but because ESG risks often become investment risks. Multiple studies have found that companies that address ESG issues, particularly those most salient to their business, outperform those that do not. This has made ESG increasingly important from the perspective of securing capital, both debt and equity. Global ESG investments exceeded $40 trillion in 2022, and it is predicted that they will reach the $50 trillion mark by 2025. In South Africa, ESG concerns present as follows. The E, environmental aspects, include climate change, energy, water scarcity and usage, biodiversity, destruction of natural habitats, pollution and waste management. The S, social issues, include employment and labor issues, employee benefits, diversity, health and safety, human rights, community relations, and the manner in which BEE is advanced. G, governance matters include corporate structure and management, strategic direction and oversight, compliance, anti-bribery and corruption, board composition, and executive compensation. Clearly, ESG reflects and demands consideration of stakeholder interests at a high level and on a very broad scale. ESG regulation is a complex and rapidly expanding area of compliance. In most jurisdictions, including South Africa, companies now have ESG reporting obligations which arise from an array of domestic and international laws and regulations, not all of them primarily ESG focused. Some obligations may be prescribed, while others, such as the Second Code for Responsible Investing in South Africa, CRESA 2, published in 2022, are voluntary initiatives aimed at developing and implementing sustainable investment. In King 4, sustainability is regarded as an element of the value creation process relevant to all organizations, and the King Code therefore emphasizes sustainable development, which would include consideration of ESG factors as a primary ethical and economic imperative. However, the Companies Act currently contains no direct reference to ESG or a requirement for directors to consider ESG factors in the exercise of their powers. South African companies are under ESG pressure from activist organizations. Non-profit organizations such as the Wraith Foundation and Just Share state that they seek to use advocacy, engagement, and activism to support active ownership and responsible investment, and they regularly propose resolutions on various ESG issues. Recent campaigns have included attempts to have resolutions tabled at the AGMs of listed companies, which would require the companies to disclose or report to shareholders on climate risk-related issues and commit to deadlines for enhanced disclosures related to climate risk. These activities have been particularly successful in pushing climate-related policies and disclosures in the South African banking sector. King 4 requires a company to have a stakeholder engagement policy. And with increasing awareness of ESG issues, companies can expect far greater engagement from other stakeholders on these issues. Increased ESG disclosure and reporting presents litigation risks for companies concerning inaccurate or misleading ESG reporting. In fact, the skewed or misleading information may be intentional. Given the growing appeal of investments which carry an ESG label, there have been a number of cases where companies have made misleading or inflated claims about their ESG credentials. When this is done for environmental purposes, it is known as greenwashing, a phenomenon that has been around since the 1980s. However, because there's no universally accepted framework for ESG measurement as yet, the potential for either intentional or negligent misrepresentation is far bigger. As a result, we are now seeing allegations of general ESG washing to achieve a particular investment fund status, as well as social washing, pink washing, and blue washing. A veritable rainbow of dirty laundry. Social washing is quite similar to greenwashing, except that corporations are trying to market themselves as socially conscious. In reality, they don't do anything beyond lip service to support the cause espoused by them in the social washing campaigns. In South Africa, highly publicized once-off Mandela Day campaigns have been noted as an example of social washing. Mining companies are also often accused of this by activists, paying lip service to their investment in employees and local communities without any real follow-up action. In a similar vein, we have pinkwashing, which presents a company as having excellent LGBTQ+ policies and practices when this is in fact not the case, and bluewashing, which refers to the practice of businesses to sign up for the UN Global Compact without any intention of ever following its 10 principles. They then use their association with the United Nations to enhance their image and shift attention from their controversial business practices. In the US, the Securities and Exchange Commission issued a statement just last week, confirming changes to their fund naming rules to deal with incidents of ESG washing, which impacts funds whose names suggest a focus in investments with particular characteristics. This includes names suggesting an investment focus on ESG-related factors through names such as sustainable, green, or socially responsible. It also includes names suggesting a focus on particular characteristics like growth or value. Under the names rule, the fund must adopt a policy to invest at least 80% of the value of its assets consistent with its name. Companies also face ESG litigation risk in respect of their activities, governance, or performance, including in respect of significant projects from an ESG perspective. Companies in natural resources and commodities industries are particularly exposed to this type of litigation and to class actions. We saw this recently in South Africa in litigation brought by environmental groups, indigenous rights groups, and tourism and fishing associations against Shell's proposed seismic surveys on the Wild Coast. You may also recall the legal action which delayed the building of Amazon's African headquarters here in Observatory. One of the claims in that dispute was that the site held great historical importance for Indigenous First Nations people. The International Corporate Governance Institute predicts that in South Africa, in future, ESG will become a core strategic concern for corporates, driven by external factors and pressures, including a shift towards a more stakeholder-inclusive capitalism, ESG-related shareholder activism through litigation and other corporate engagement is likely to become more prevalent and sophisticated, and ESG sustainability disclosures and reporting will continue to remain an area of focus, with a gradual shift towards more standardized reporting expected to take place. In a recent UK case hailed as a world first, Client Earth, a not-for-profit environmental organization, brought a derivative claim as a shareholder of Shell against its directors, alleging breach of their duties under sections 172 and 174 of the UK Companies Act. Client Earth bought 27 shares in Shell plc so that it could make this claim. This made headlines because it was the first English case to allege that directors could be in breach of their fiduciary duties for failure to adopt a reasonable climate change risk strategy. As we know, Section 172 requires directors to act in a manner that the directors consider in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. In doing so, the director should have regard, amongst other matters, to the likely consequences of any decision in the long term and the impact of the company's operations on the community and environment. Section 174 requires the director to exercise reasonable care, skill, and diligence. In order to institute this type of action, a claimant must receive the permission of the court to proceed with a claim. court can dismiss the claim if it does not appear that the application and supporting evidence creates a prima facie case for providing permission. In May 2023, the High Court refused permission for Client Earth to continue its claim against the directors of Shell. The judge concluded there were a number of reasons why Client Earth did not establish such a prima facie case. For present purposes, most notably because, firstly, the management of Shell's business was for the directors to determine, including how best to promote the success of the company. And secondly, Client Earth's case ignored the size and complexity of Shell and the fact that the directors of Shell will be required to consider a range of competing considerations that the court is ill-equipped to interfere with. Mr. Justice Trower was particularly critical of Client Earth's ulterior motive in bringing its claim. He apparently believed the claim was driven by Client Earth's beliefs as to the right approach for dealing with climate change, rather than a genuine need to use the legal remedy in question as intended. In other words, he questioned the bona fides of Client Earth in using a company law mechanism to further its climate change agenda. According to UK legal practitioners, this is surprising and contrasts with some judicial reactions to climate activist litigation in other jurisdictions. Client Earth requested an oral hearing to make further submissions. However, in his second judgment of July 2023, Judge confirmed his initial view and refused Client Earth permission to continue the claim. The key point on which the judge confirmed his initial view was in considering the bigger picture of directors' duties, stating, "The way in which Client Earth puts its case seeks to impose absolute duties on the directors, which cut across their general duty to have regard to the many competing considerations as to how best to promote the success of Shell for the benefit of its members as a whole." Client Earth have indicated that they will appeal this decision. Given the limited case law surrounding Section 172 of the Companies Act, any decision of the Court of Appeal is likely to be seen as creating a precedent to be followed in respect of that part of the Companies Act. What does all this mean for South African company law and directors of South African companies? In terms of South African law, directors owe their duties to the company, not to the shareholders or any other particular set of stakeholders. The Act purports to adopt an enlightened shareholder value approach, but the section dealing with directors' duties makes no mention of this. Even if directors unreservedly agree that their duty to act in the best interest of the company necessarily entails taking the interest of a range of other stakeholders into account in all of their decision-making, they still face some challenging underlying questions. For example, which stakeholder interests can properly be taken into account and to what extent? Is this mandatory or voluntary? Must it be a formal process as part of board decision-making, or can it be more informally undertaken? If there's a direct conflict between various stakeholder interests, do they all carry equal weight? Or are some more important in certain industries, jurisdictions, or circumstances than others? What if there's a direct conflict with shareholders' interests, which requires a significant trade-off? Are shareholders' interests more important? And if so, how much more important are these than those of other stakeholders? How far into the future must a board look when shareholders' interests and the sustainability of the company are taken into account? And to what extent must directors justify their decisions and actions, and to whom? The obvious question which arises from this is whether it is desirable to amend the Companies Act so that it more accurately reflects the duty of directors to take a wider range of stakeholders into account in the exercise of their powers, as the UK does in Section 172. Ultimately, UK directors need to use Section 172 as a tool to steer judgment and make decisions that will promote the success of the company, having regard to the long term. And this approach would be in keeping with our common law. Initially, I was of the opinion that we should follow these modern legislative trends, but I'm no longer convinced that this is the best route for South Africa at present. In August, New Zealand passed an urgent amendment to their Companies Act to clarify that directors may consider matters outside of the maximization of profits, naming ESG factors specifically, when determining whether a decision is in the best interests of the company. This amendment has been criticized, not for its intention, but for its wording, which critics allege causes even more confusion. If we do decide to amend the South African section, we will need to ensure that we get it precisely right, or it may make matters worse by inadvertently creating more confusion and reducing the flexibility and discretion in decision-making that directors currently have. It will also add yet another layer of regulation and compliance to the heavy burden companies already carry. This is not justifiable and should not be done unless it adds real substantive value to the goal. Furthermore, with the rise of public appetite to support sustainable businesses, the increase of climate-related and other regulation, as well as the reputational damage that can negatively impact companies who do not comply, directors should already be of the view that considering ESG factors is consistent with acting in the best interest of the company. In that respect, amending the Act will not achieve anything new. I think the most concerning approach South Africa could take would be to start making further piecemeal amendments to the Companies Act to protect or include various stakeholders. And I would caution against this. I do think that may be the direction we are heading in, however. Some critics are predicting that the trend of ESG investing will fall away, and there's currently ESG pushback brewing in the US at both state and federal level. However, the challenges around sustainability in business are not going to disappear. Global developments continue to move firmly in the other direction for now. The European Union's Corporate Sustainability and Reporting Directive came into force in January of this year, and it mandates that companies disclose environmental and social risks and opportunities. In the coming months, the EU is also expected to adopt a human rights and environmental due diligence directive. This will require all companies doing business in Europe to assess human rights and environmental risks in their supply chains. Thus, for modern directors, conducting business sustainably includes managing the interaction of the business with the environment, society, and economy in which it operates towards a long-term better outcome. Evaluating the sustainability of the business of an entity includes the consideration of economic and ESG factors. What is clear, therefore, whatever approach is ultimately adopted regarding the wording in the Act, is that, firstly, ESG factors are and will continue to be a significant consideration for directors, and secondly, that expectations and complexity of directors' duties continues to grow. At its company law core, the impact of these various complex developments is therefore actually quite simple. The ESG and stakeholder capitalism movements are fundamentally about good governance. They serve to strengthen due diligence in the exercise of a director's fiduciary responsibilities within a business context which is undergoing profound and irreversible change. If we go back to our starting point with the West Cork Railway Company case in 1883, do these developments mean that modern company law now dictates that all stakeholders are entitled to cakes and ale? No, it does not. In law and in reality, the cakes and ale will still largely be reserved for the company and thus the general body of shareholders. However, these developments do imply that, despite the lack of a specific reference to this in the Act, directors have both a legal duty and an ethical responsibility to consider who else at any given time should be invited to sit at the company table with the shareholders, and to ensure that the cakes and ale are not baked, brewed, or served at disproportionate cost to any other shareholder. Thank you very much to the university and the law faculty for hosting and organizing this event, and a heartfelt thank you to you all for your time and attention.
Very much, Professor Yeats. It gives me pleasure to invite Professor Michelle Lowe to deliver the vote of thanks.
I think we can all agree that she professed today. At least taught us that there's different laundry. Becoming a professor is the pinnacle point of one's academic career. It's the highest academic title bestowed upon an academic, as the Vice-Chancellor has mentioned. In a typical academic career, there are many firsts to celebrate. your first journal publication, seeing your name in print for the first time, your first book or your first book chapter, delivering your first conference paper, obtaining your PhD, delivering your first PhD student, and finally becoming full professor. It is then when your academic career comes full circle. Today, we welcome Jackie Yeats to the ranks of professor. However, becoming a professor should not be the end of your academic career, but rather the start of a new chapter. Being a professor also comes with greater responsibility. Professional leadership is linked to a record of scholarly and professional achievements in the relevant discipline. Professors are a critical resource within the university, possessing a range of skills and knowledge that can attribute significantly to the quality of the institution in a variety of ways. Professors take key roles in teaching within faculties, schools, and departments, are prominent among the university's many researchers, and visibly represent the university to interest groups in the broader community. Professors provide creative leadership in responding to change and the implementation of initiatives as they arise. Professors as leaders in their disciplinary areas also have an important role and responsibility to mentor other academic members of their discipline. This can and should take many forms. At its highest level, mentoring includes becoming a trusted counselor, guardian, and teacher. It includes informal, responsibly advising and assisting of one's junior colleagues, and it includes collaboration with colleagues in research, scholarship, and teaching, willingness to accept appropriate performance management and developmental roles, serving on promotion and selection committees, serving as external reviewers and referees, and serving as PhD supervisors and examiners, amongst others. Professors have an obligation to mentor those who are new to academia, young members, and other academic staff, and even those new to academic positions, even those coming with considerable professional and industrial experience. Professors also have an obligation to advise and assist associate professors and others with their extensive experience in academia, and to mentor and to bring intellectual networks those whom they may not have had prior equal chance of professional networking. So it's a lot of work, Jackie. But it is not for me to sing Jackie's praises or read a full CV. Johan has done that. Professor Harting has done that. By becoming a professor, she has already shown her academic worth. I will, however, highlight only a few aspects that make her different. She won the Teaching Award and is part of a national cohort of recognized and exceptional teachers. She led the writing of the corporate law text that Johan has alluded to, and that comprised of a team of authors not only from UCT but also from other universities. She was instrumental in creating the Corporate Law Research Unit, UCT, which we've heard. Jackie brings to the Faculty of Law, in terms of expertise and uniqueness, in my view, the manner in which she convenes and teaches the LLM corporate law. She brings to the table her connections and a wealth of experience from practice. Becoming a professor also comes with many sacrifices, particularly from the loved ones. Jackie's family, in particular her husband and the kids. I believe you have 4, but only your 2 favorites are here today. We're not favorites, you are favorites today. I have only 1 kid, and anything more than 1 sounds like a lot of work. I am sure that many balls were dropped at home. As Jackie navigated the role of being an academic and a mom simultaneously, I assume there is some balls that were dropped, some projects left behind. Women's Lib said working moms could have it all. Well, I'm still thinking about that one. I know from experience, the only time a mom can cut on her time is on herself. You don't often see academic females with long nails and so forth. I therefore thank Jackie for her time and effort dedicated to UCT. I would also like to thank people behind the scenes that enable academics to reach their full potential. From former heads of the Department of Commercial Law, the current and former deans of the law under which Jackie served, the staff in the library, the current and former administrators of the department in commercial law, and colleagues, especially junior and senior colleagues, especially those also in your field of expertise. Last but not least, I would also like to thank UCT, of course, because they pay your salary and they are here. But that is not the only reason. I would also like to thank UCT for supporting Jackie's academic and research endeavours over many years and for entrusting faith in her by promoting her to full professor. I welcome you to the ranks of professor.
Professor Lowe. That brings us just about to the close of proceedings. I'd like to add my thanks, appreciation to CH accessible, enlightening lecture and discipline that's distant from us. Thank you for that. The platform party will now leave and thereafter you can join us. So I think I'll act in the best interests of all of us by inviting you to join us for refreshments in the faculty common room. Thank you for being here.